Thanks everybody for coming out to this special seminar. This is Andrea Casillas from the Open Invention Network. She came up from New York to talk about patent law and software and kind of how it affects you guys being undergrads and beyond. And I'll leave it to Andrea.
Yeah, thanks. So can everyone hear me before I start? Thanks for having me. I'm Andrea Casillas. I'm here with Open Invention Network. I'm the director of Linux Defenders. So I'll briefly talk about what the Open Invention Network does and then move into a little bit about intellectual property, then to patents, and then I'll tell you exactly what we do on Linux Defenders. So the Open Invention Network. We're committed to protecting freedom to operate around Linux and open source. So we aim to create this no-fly zone around open source by having stakeholders pledge non-aggression. So with the Open Invention Network, there is a licensing aspect, a part of it. I don't really focus on that. I focus on the IP and the intellectual property that we'll get into next. But we are focused on limiting the threat of patents and removing the threat that they have to innovation. And I'll show you some examples of that. So before I dive into exactly what Linux Defenders does, I'm going to kind of introduce intellectual property, IP for short. Basically, intellectual property was created, for us, at least in the US, by the US Constitution. So Article 1, Section 8, Clause 8 says that Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So what does that mean? Basically, we get this bargain, right? So we get the author or the inventor or the creator putting out their intellectual work and sharing it with us, with the public domain. But in exchange for that, in exchange for promoting this innovation that they are doing, we give them some kind of legal protection from people copying what they're doing so that we can continue to motivate them to create more. So that's a really high-level view of this, but essentially it's a bargain that we want to keep people doing this because we see intellectual property, creative work, science, everything that comes from it as useful and beneficial to the public in general. So from this idea, this is basically the forms of intellectual property that we have. So trade secrets, you've heard of them, but they're formulas, practices, processes. Usually they're within the companies. Trademarks, names, logos, symbols, everyone sees these all the time. And then we start to get into our exclusive rights. So copyright, we get into protecting the expression of ideas. And then patents is when we invent from these ideas. And there are constraints on getting this kind of patent protection. Basically, you have to have something that's new, useful, and non-obvious to the public at large. And then just to give you an overview of the duration, these trade secret is something, we'll get into it, but it's an indefinite time that you can have it. Trademark, as long as you're using it, you have a trademark. Copyright, I say forever. It's not really forever, but it feels like it because these time periods kind of just seem to keep on extending. But patents, it's a set time. It's 20 years after filing. Then you're done. And it's the most definite out of what all these other forms of intellectual property. So trade secret, and I'm going to just give this very, for a lawyer, this is going to be a problematic overview, but it's just a generalization so that we can kind of get the idea of these forms of IP. But the value comes from trade secret in keeping the secret. So this is a contractual thing. You usually see it in non-disclosure agreements, which someday you might run into. But it's not the company proprietary information that's being protected. It's what the confidential information within the company that's being protected. But it's not definite. So once this knowledge is in the public domain, you can't get it again. Once it's out there, it's done. Trademark. So like I said, we all know these kinds of marks that we see. But the main point of these is to prevent consumer confusion. It allows for the product differentiation and a reputational consistency. So you know when you see Coca-Cola what you're getting. Same thing with all these. You know there's not a confusion. Nobody's going to, well, you'll get sued if somebody comes up and uses Google's logo for shoes that are not made by Google. And then we start to move into these exclusive rights. So copyright, like I said, is an expression of an idea. And the idea of copyright is that by sharing your creative works, you basically breed the creativity. So people see your creative works and then it inspires them to do something. So you get all these different ways that you can actually express your ideas and they're protected. So you get the right to reproduce, the right to create derivative works, right to sell, lease. You see all these things that pertain to copyright. And generally, copyright is what protects software, generally. But we'll see that it actually bleeds a little bit into patents. So patents, like I said before, is the right to exclude. You don't get the right to invent with a patent. You get the right to exclude others from using your invention without permission. So when you get a patent, you're fully disclosing to the public your invention, and you're disclosing the best way to make your invention and how, just everything to the public. But in exchange for that, the government will give you a 20-year monopoly, which is something that usually monopolies aren't a good thing. But in this context, the idea is that we want to see more innovation. So we're going to encourage you to do this, and we'll give you some rights in addition. So you see these rights that you get: making, using, selling, offering for sale, and importing goods. And it always comes to a surprise for inventors when they get a patent that it's just they have to then be active in protecting their patent instead of being able to just say job well done for getting the patent. So that's why we see a lot of lawsuits and whatnot. But so generally, this idea of patents works well. I mean, you can see that patents have been getting awarded in increasing amounts every year. And if we're going to software, we can see that it's also increasing in the amount of patents that are getting awarded. This just demonstrates the amount of software patents that were awarded pre-1991. But for the most part, we have this very steep increase in software patent grants. So that must mean that we're innovating, right? It's a good thing, right? Well, we also see that with all these software patent grants, the amount of litigation is rising. And keep in mind that this represents the numbers in the US, but this phenomena is not just focused in the US. The second biggest market for software patent lawsuits is in Germany, actually, even though Europe doesn't necessarily allow software to be patented. So it's a little bit interesting, the amount of litigation that we're seeing. And this chart represents the amount of lawsuits filed by non-practicing entities. Does anyone know what a non-practicing entity is? Okay.
Companies that don't execute on the patents, but they charge license fees.
Right. So they go try to get all the patents they have, and their revenue is derived from getting people to license because they're threatening lawsuit. So they are, in the patent world, known as trolls. And actually, it's perfectly legal, but is it right is a whole different story. So this chart shows that these trolls are initiating more and more lawsuits. And this increase, which is pretty drastic now, starts to explain why there's a lot of apprehension around inventing, or there's a fear of getting caught, or a fear of disclosing what you're doing, because you're worried about whether or not you're infringing or whether or not someone's going to sue you. And just to give you another idea of how this is looking, just in the smartphone world, which I'm sure many of you have heard about the litigation going on with Google and Samsung and all these phone companies. But in the last 2 years, we're at $20 billion invested in just litigation. Think about what could be done if that was invested in research. And just a fun fact, it's the same cost as 8 Mars rover missions. So what's exactly going on here? Okay, let's see if this works. So when you apply for a patent, there's a process, and it's called patent prosecution, where basically you apply for the patent, and there's an examiner that reviews it. So I'll just go over this quickly, and again, it's a generalization, and then we'll look at the problems with this process. So first, your patent application is filed, and this is no small feat. Writing a patent application is pretty costly in itself. It does involve usually a patent lawyer, and usually the end result is something that the inventor really doesn't understand, but that's beyond the point. So your patent application is filed, and then it enters this queue, and this is about an 18-month line to just get a response. But after this 18 months, then it's published, and so everyone can see it. So it's published every Tuesday. Everyone can read all 6,000 plus patent applications that are posted on the USPTO website. Somewhere between 18 and 24 months, you get what is called an office action. And that's basically a communication from the patent examiner that says what's going on, whether they rejected the claims, whether they approved them, what you have to do to change it. It's kind of, it's not a long document, but it gives you some kind of answer. And usually the first response is a rejection. So then the applicant is given an amendment. They can amend this application, try to get around anything that the examiner finds, which is actually the patent examiner is looking for what is called prior art. So prior art is basically evidence of whether or not this invention is new. So they're trying to prove that yes, it's new, no, it's not new, and here are the reasons why, and they'll list the pieces of prior art for the applicant to see. And then they'll get a second office action, and this process kind of goes back and forth. And it can end with a patent being awarded or just a rejection. But I mean, in the end, I mean, this prosecution just with the office actions can go 1 to 3 more years. So this process can take somewhere between 5 and 6 years total. It's a very long and costly process. But there's some challenges that the examiner faces when they're reviewing these applications. One is that they can't spend any more than 20 hours total for each application. And that's 20 hours over this 5 to 6 year period. It's crazy, right? 20 hours. But this doesn't just include the important stuff. This includes that the application is following the rules. So you get this huge handbook, and that's to comply with all these little rules, and the examiner has to make sure it does. Determining the scope of the invention. So that basically means that you can't say that you invented the world. You know, you have to have a finite, small scope of what your invention is. Issuing office actions. So these can, I mean, sometimes you get, on the low end, you get like 2 office actions. On the high end, you can get 8. And we'll see one application that got 9. So this is also a process. And then the last one is parsing through legalese. So legalese is pretty problematic. What I call legalese is basically the overly broad and vague words that are used in claim language. And they're used by the patent attorney in hopes of getting the broadest patent for their client. But for the patent examiner, they require some kind of deciphering because it's not necessarily known. And like I said, the inventor, after they see these applications, they don't really understand what they invented at this point. We'll get into the legalese a little bit. But yeah, so in the end, just 7 to 8 hours are spent, and that's 7 to 8 hours max spent searching for prior art. So 7 to 8 hours just looking through to see if this is actually inventive. So this is a list of everything that's not typically searched. I mean, we can concede that the patent examiner is pretty proficient at searching through patent literature, but all these non-patent literature, like publications and reports that they do not search, it's pretty staggering, particularly for the open source community, because their whole point is that they're not patenting. So their work isn't being reviewed through these vehicles. Oops. Oh no. You think? Ah, yeah. Good call. So, in light of all these challenges and the time constraints and everything, there have been some questionable patents that have been issued. Did you have a question? Oh, I thought you were raising your hand. Okay. And we'll go through them really quick. Method of exercising a cat. It involves a laser. There we go. Another one, animal toy. Piece of wood. Awesome. Method for swinging on a swing. We all knew that was going to happen, right?
Are these illustrations from the patents?
Yes, these are the patents. There's actually a blog of patent illustrations. There's no context given. It's amazing.
Are these successful patents or unsuccessful?
What'd you say?
Are these successful patents?
So these were issued, yeah. They have since been invalidated, but still, they were issued, right? If you look at the dates, 2002, method swinging on a swing. Come on, we've been doing this for a while, right? So it gets into the claims and the claim language and why it's so vague and why people just don't understand what's going on. So obviously these patents aren't they're not going to stop innovation, right? They're silly, stupid patents that were issued. And that's fine, that's one thing. But what happens when they do threaten innovation? And so we're gonna look at this example. Hopefully I can handle this a little bit better. And this is for the Microsoft FAT patents. And it's just to illustrate how insane this can be if we let it. So Microsoft has awarded these FAT patents, which are file, oh, I have it up here, okay. So there are these 4, 5, this one stands for European patent. And so FAT, short for file allocation table. And as you can see, it's a technique for storing very long file names in old file systems that are designed to use very short file names, used to allow Linux and Unix to exchange data with Windows computers. When these were issued, no one really thought about it because it's something that when it was, at the time it was issued, everyone's like, well, whatever, we've been doing that forever. No one really saw a threat. Well, no one saw the threat, but Microsoft saw an opportunity. And they understood how widely used this technology was. So in 2003, Microsoft has announced that their FAT patents would be incorporated into their licensing portfolio. And then it all starts to hit. This is the licensing terms per device. And you can imagine that a lot of devices are using this. And so we start to see, for a problem with this. So PubPat is this organization out of New York City that goes after, tries to invalidate bad patents. And so they made a request to the USPTO to revoke one of the most problematic patents. And they did find prior art that was unseen by the examiner. And so this is what they quote. Microsoft is using its control over the interchange of digital media to aid its ongoing efforts to deter competition from free and open source software. And this was the first whistle that went on for this. And so they seem to have won at first. The USPTO rejected this. And in this rejection, this was due to a re-exam. So you can, first we'll get into how much it costs, but you're allowed to give them your prior art, and then basically you're out of the process. So Microsoft then sees this rejection and makes amendments. And then after these amendments were made, the office, the USPTO, reviewed it again and made another rejection. But this time, it wasn't based on the prior art. It was based on some technical discrepancy that could easily be amended. So Microsoft did, and these were reinstated. And so then we start to see the lawsuits. In 2009, Microsoft launches lawsuit against TomTom based on these FAT patents. And then we start to see how it's going to start to affect Linux. And TomTom starts to settle, agrees to pay Microsoft money and removes the functionality covered by the FAT patents. And then this case starts to get huge because then they go after Motorola. And they go after Motorola in both the federal court and the ITC. And this is something that we're starting to see a lot of now, both forms of litigation. So just a quick overview of the ITC. The ITC is an administrative court, so it's separate from the normal legal system that we see. But the procedure is you get a result much faster. So you see the comparison, 14 to 24 months versus just years and years and years of litigation. So your complaint gets filed, an investigation is launched, trial, hearings, and there's an initial determination. So then this initial determination is investigated again, just as a backup by this commission. And they decide whether to review, adopt, reverse, but they'll ultimately render a final decision, which is why it takes the 24 months instead of just 14. So initially, the ITC made a determination that Motorola violated these FAT patents. But then Linus Torvalds testifies about a post that he made predating these by 3 years. Oops, where did you go? Oh no. Well, I'll show you the post later. But based on this post, the ITC takes this into consideration, and they actually invalidated the FAT patent. So that's a great thing, and everybody was very excited. But keep in mind that there's still the other action in federal court going on. So this is just an initial determination that says, okay, you can start importing your goods again. Now we have to still wait for litigation. But oh, go ahead.
So all the companies that were paying Microsoft, did they get reimbursed?
They made the settlement, so it's done. And you can see that Microsoft wasn't done yet, because this initial, or this determination by the ITC doesn't necessarily affect the other litigation that's going on. They can take it into consideration, but it doesn't mean that it's done by any means. So then Microsoft still goes after Barnes & Noble. And this time, Barnes & Noble decides that they want to try to fight back. So they publish this letter that's kind of exposing Microsoft. Mm-hmm. Yeah, so what they said is the patents we read cover only arbitrary, outmoded, and non-essential design features, and yet Microsoft is demanding prohibitively expensive licensing fees. Microsoft is intending to drive open source out of the market. So Microsoft wants to get into the tablet. And for their fighting, they ended up settling. And we see now that the Nook runs Windows. And meanwhile, well, Microsoft is going after everyone else, because you still settle. It's not going to court. So we have 15 companies that have already settled that are based using open source. And now we see it in Germany too. So the German judge ruled against Motorola. And so now Motorola's Android devices are completely banned from Germany. So that's just kind of one illustration of the madness that is going on in the patent world. And so we can see with the FAT patent, Microsoft was able to flex their muscles and directly threaten open source technologies, namely Android in this case. So what does that mean for us, right? What do we do? There are outlets that the public can participate, and that you can participate as you're creating and inventing. And so I'm going to go through them. So you can, this is the most traditional. There's about 3 routes where the public can participate. And the most traditional route is after the patent has been awarded, after it's been published. And it's either through some kind of lawsuits for infringement, or some kind of re-examination to show that the patent's invalid. They sometimes go hand in hand, usually in court cases, but you can do the re-examination without the lawsuit. But if you do, these are the amounts that you will be expected to pay, or you should expect to pay. And obviously, this is maybe doesn't mean so much for a big company, but for you, the inventor, or me, the small startup company, this is pretty staggering. And it's just going after an infringement suit. It just really isn't an option for normal people, right? So you can also go through the reexamination process. And this is the cost for a reexamination. And they actually implemented some new ways or new avenues to pursue a reexamination. But basically, when you go after an application or a patent in a reexamination case, you're asking the patent office to admit that they made a mistake in granting this patent, and you want them to say that they are wrong. So it's a pretty high burden. It doesn't happen often, but it does, or it sometimes happens, but you can see the cost, right? So the most you could expect to pay is $200,000. This, it's hard to see, but it's about $12,000. Still not necessarily feasible for small inventors or individual developers. And it's also timely. It takes a lot of time to actually get a final result. So that's one avenue. Oops. The other one, the second avenue, is actually during the patent application review process. Recently, I would say within the last year and a half, 2 years, the patent system got reformed. And that took 50 years to happen. But it got reformed with the American Invents Act. And the American Invents Act basically allowed or created this avenue for the public to submit prior art to the examiner for free. And you can submit up to 3 pieces of prior art. And you can actually annotate where to look. So you can guide the examiner. You're not giving them more work to have to read a whole huge document, but you can tell them, oh, look at this. This relates directly to these claims. And this is pretty historic and helpful to the examiner when they're not searching all these other scientific publications, when they're basically not searching non-patent literature. So it is helpful. But the only problem is that you can only submit once. So after you make your submission of prior art, the examiner can take it to review and say they use it. Then the applicant gets their opportunity to amend their application, and you're done. You don't get to get involved in this process beyond the initial submissions. So it's helpful, but it is still a little bit limiting. And I'll give you just an example of we can still see that the challenges that the examiner is facing are still prevalent, and the system is still taxed with this Siri patent. So all these red dots are all the rejections, the office actions that they got, that Apple got, saying that your application has been rejected, 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 rejected. So it wasn't until Apple actually altered their terminology to include the words predetermined and heuristic modules that the patent was awarded. And so, I mean, predetermined, how vague is that, right? So it kind of goes into illustrating the legalese that goes into these is still a very problematic issue that the patent examiners are dealing with. And the legalese becomes really important in this process. Did you have a question?
No.
Okay. So the third route is actually through defensive publications. So what are defensive publications? They're a publication that prevents another party from obtaining a patent by disclosing the enabling components so that it enters the public domain and becomes prior art. So you're basically creating prior art. And it's not a new thing to do. Actually, all of these companies have been doing defensive publications, and they've actually integrated in their IP strategy. And their strategy is basically they'll get their patent and then create a bunch of defensive publications around their patent so it can kind of expand what they have already patented. So it's a little bit of an abstract use, but defensive publications have been around. And it's actually something that I focus on, but used in a slightly different way. So we'll get into why I'm here. So the Linux Defenders program is where this all kind of ties together. So in order to effectively prevent the threat of bad patents, we in this program, we use all of these resources that we have, either after the patent has been issued, during the patent application process, or even before any kind of application has been written, to kind of combat the threatening patents that we see or prevent them from ever being issued. And we're, again, preventing them to help protect open source and kind of promote this innovation that we see collaboratively. And again, these are just the 3 points that we can interfere in the patent process, but we go at it from all 3 of these points because there is no one tool that you can use other than completely saying that software cannot be patented. But it took 50 years to get to this point. I don't know how long it's going to take to get a next Reform Act. So the point is to limit and remove the threat so that you can keep on inventing and you can keep on doing what you like to do, and kind of go back to that whole bargain that we got from the Constitution. So the approach to patent busting, which is basically the same as going after applications or patent applications, is that we will search for the threatening patents or applications, find the prior art, and then submit it to the examiner. The process is a little bit different. If we go after already issued patents, it's going to be, the prior art's going to be a little harder to find, but we'll definitely do it. But we rather, if we're going the prior art route, we rather get it at the application stage so that we can freely do this and get it before it's wreaked havoc, basically. But the longer we wait, like we went over, the more expensive it becomes. And so the more expensive and more dangerous it becomes for us. So we are pushing defensive publications. And this is actually what you should have seen before in the timeline. This is the submission that Linus Torvalds made. This is, for all intents and purposes, a defensive publication. And this is what is used in the ITC to invalidate those FAT patents. So you can see it's not a huge document, and you can understand the words. So it's not a patent application or a patent at all. And it was used, again, to invalidate something that was crazy. And so this is why we're pushing defensive publications. If we look back at these FAT patents, the community knew that this Microsoft FAT patent was not at all innovative. But there really wasn't the means to get it to the examiner to show them that whether or not this was inventive. So what we're trying to do is actually get these kinds of publications to the examiner so that before they grant a patent, they actually see everything. And then you can just kind of imagine what we could have avoided had the examiner had this document in the beginning. So a defensive publication. How do you write one? It's really simple. I mean, you have a title, 1 to 2 pages. It's not a very long document. It's a very short, brief, but descriptive document about what you're working on. And it's something that doesn't have to actually work. For a patent to be issued, you have to show that it actually does the job that you say it does. Here, it's an idea that you have, and you're going to try it out. And if it doesn't work, well, hey, that's OK, because it doesn't have to. But the most important part of this entire process and this document is actually explaining how you think you would envision your technology to work. And let me just show you an example of one. Oh, it's a little bit hard to see. But usually there's some kind of problem that they're trying to solve for. And just a description. Diagrams usually accompany it because it helps to show the step-by-step process. But it's not an overly, it's not a thesis. It's a very simple document. We want to make sure that it's simple so that when the examiners gets it, they understand what's exactly going on. So this is just a diagram of exactly how they think everything would work. So how are we involved? Oh, yep.
Are the examiners technical?
Yeah, so they're all separated depending on what technology, right? So biotech is completely separate from software. But even within like the biotech or the software departments, they're further divided. And even like your patent applications that go in, you'll see that there's certain, they have different classifications depending on what they're for. And sometimes those classifications change depending on how the amendments go. But yeah, they're all separated, and they're considered pretty educated in what they're researching. That being said, they're no longer creating, they're reviewing applications. So they don't necessarily know what is inventive, which is why they search for the prior art. So Linux defenders. So we're involved in obviously trying to get people to write these. Yep.
So when you write up your defense
Publication.
how do you have to present it to the world? Does that be on some
Yeah.
legitimate.com?
No, so I'll get that. So here, we'll get into that right now, actually. So we don't want to give the examiners any more work, right? Like everybody has their blogs. What you post on a blog is equivalent to a defensive publication, right? It's just that the examiner doesn't have time to go to that blog. But where we post all these publications is on this resource called ip.com that patent examiners use in their regular search. It's not asking them to go to one other website. It's actually, they have a database, they search fields, and it pops up in their database automatically. So we filter it all to the patent examiner directly. And we get involved by coming to speak to students and going to conferences because this is something that really isn't being used, and it should be because it's a free resource that you have to help protect yourself and set yourself up for the future. Yep.
Often in the patents they use different words or descriptives than would normally be applied to it, so that it's harder to invalidate it. Do you try and use the same descriptives?
Yeah, no, we don't, because we'll use words, say you're creating something to use specifically on Linux. We're going to tell you, hey, don't put Linux in there, use a software, or something that's general, but not a component that plugs into a computer that blah, 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 not something like that. So we're not trying to match the vagueness of the patents. We're trying to make it understandable so that when they get these 2 to 3 page documents, the examiner can read through it and understand what's going on. And then when they look at the application, they're like, this application is, reads on all of this. Or, it's something that they can quickly relate. Because again, we're not trying to add to their already huge workload. We're trying to make it easier. So what we do is you basically submit whatever. I submitted on linuxdefenders.org. I and my team, we review these and basically contact you, and you're like, hey, this could be improved, and we'll kind of guide you to make sure that we can make this defensive publication the most effective defensive publication. And after it's done, and we don't make the edits, you make this is your work. It gets posted on ip.com. ip.com acts as a digital notary, so it puts that date on there, which is very important in the patent world. And then the patent examiners can use it when they're going through their prior art search. But what it works for you is that in the end, when you get this publication on ip.com, instead of having a list of a bunch of patents on your resume, you can now have a list of a bunch of defensive publications which is another cheaper route to kind of rounding out what you're already doing and showing the world, basically. Is there any questions on that? Yep.
Yeah, so you said that defensive publication, you can publish things that may not work.
Yep.
So isn't it kind of, in some sense, you may be stopping creativity?
So you're not getting
good ideas from coming out.
No, no.
This bad idea that doesn't work on
right.
publication.
So you're not getting a right when you
may be stopping other people from making a thing that works by publishing things that don't work.
Not necessarily, because you're publishing how you think it would work, right? So you're saying, this is what I think I can do. And if it doesn't work, that's fine. They can read it and they're like, no, this doesn't work at all. And they can publish whatever they want. What you're doing for yourself is showing to the patent examiner where the state of technology is in your field, right? So you're showing, and it goes back to one of the requirements for getting a patent, you're going back into the non-obvious area. So would it be obvious to take these steps? And if they see that it would be obvious because you tried it and it didn't work, it's still not inventive. So what you're doing is you're saying, okay, I am not going to patent on this when you file a defensive publication. I'm not going to patent this, but neither can anyone else at this point, whether it works or not. But maybe they get it to work the way that you do. That's fine, but then they can't come and sue you, and they also can't get a patent because you've already shown that it's not a new way.
I guess I'm concerned about genuine creativity. The people who make it work eventually would get blocked by your defensive publication because the patent officer thought that it is already prior art, although it doesn't work.
Yeah, but you're not, if it doesn't work, then they're not going to get a patent anyways. Like they have to show when you file a patent that it does work.
So I think, to address your concern, you would address this prior art in your, you would address this public disclosure as prior art in your patent application and say, here's what someone tried, it doesn't work, here's why my idea is clever because it's wrong.
Yep. Yeah.
How long does it take to apply and publish a defensive publication?
I mean, it's basically however long it takes for you to write it. It's one of those things that as soon as you submit it, we get back to you. We review it, get back to you. It could take a day, it could take a week. It just kind of depends on whether any edits had to be made or just how much time you have, basically. Mm-hmm. So, yeah.
Can IP.com also serve as a reverse engineering source for corporations?
For corporations?
Well, to take out things that they
So yeah, you're putting something into the public domain. So somebody can say, anyone, whether it's a corporation or not, can see it and be like, oh, I'm going to try this. This seems interesting. But the point of it is that you're not trying to prevent that. You're just trying to protect yourself from being prevented from doing that, right? So you as a developer, you want to, create X, and you're going to write a defensive publication about that. Now, you can still create X, but somebody else can as well. And in that sense, maybe it's bad, and maybe you don't want to do it, and that's fine. There are plenty of people that, will, like I said with the companies, they'll get their patent, and they'll still disclose some parts, and then they'll defensive publication around it as their strategy. What we're doing is just saying, okay, it's all out in the public domain so that you don't get sued. So if it's something that you wanted to possibly profit on, then we would say, maybe you shouldn't put it out yet. Maybe you should wait. But that's kind of up to you as far as what your plans are. But if you're just looking to be able to continue to create whatever you're creating, then it's a good way to make sure that no one else can stop you. Yep.
What's the intersection between this and open source licensing?
Well, we actually work with all open source companies, and you can still license however you want to license. I mean, because you're saying that I'm not going to patent, and you can't patent when you put a defensive publication up. Like you've already given.
You can license it any way you like.
You can license, yeah. Yep.
So I mean, this addresses patent issues, doesn't address copyright issues.
No.
What you created is still protected by copyright.
Any other questions? So yeah, this is the gist of everything. Obviously, we need your help. My team, 5 people. We have to review the patent office every Tuesday, like I said, go through all of their applications to find the threatening ones. And we do, and then find prior art. So sometimes we post like patent busting projects. But most importantly, we like defensive publications. And we see it both as an opportunity to post what you're doing and protect what you're doing. But we also are using it as a means, almost in patent, we use it as a weapon. So instead of the companies getting their patent and doing defensive publications around it to kind of like give their patent more breadth, we like to turn them on themselves. So we will then identify a patent that maybe we can't get rid of, but maybe we can try to box it in by writing a bunch of defensive publications around it. So there's a lot of opportunities to work with us. We have we have a lot of work and a lot of those kinds of strategies that we like to implement. So if you're interested, I mean, please see me, because it's cool to write your own defensive publications and get your work, well, at least protect it, or at least protect what you're doing. But it's sometimes people like to have a goal, and sometimes their goal is to go after others that are being bad actors in the world. Did you have a question?
Sure. There's a lot of potentially threatening patents out there that are being filed, so you probably have to have some topical way of filtering those down. Is there a few companies or non-practicing entities that you look at everything that they do?
If they have a history, yeah, we'll focus on them. But I mean, to be honest, there are a bunch of non-practicing entities that seem to just keep on popping up. I mean, so for the licensing that we do, if there's some kind of specific threat to one of our licensees, then we'll look into those companies first. But I mean, if there's something like we see with the Microsoft patents, we'll kind of go to that too. Like, it's one of those things that there is a benefit to all working together, especially in this open source area. And since everyone seems, it's such a vast network of people, there is the knowledge out there.
So if you are reading through patent filings, if you enjoy that and you see something that's bad, then
If you enjoy that, let me know.
who knows if it comes up.
No, but I mean, there's plenty of times that you see, some blog posts go up there like, can you believe that they filed a patent on this? And yeah, it helps for us to focus on that instead of whittle down our number of patents that we have to look at. Anyone else?
So how do you get your funds? Do you get funded by the government, or?
No, so actually OIN was founded by IBM, open source, Red Hat. It's been a long flight. A bunch of different companies, I think, I would say about 8 years ago, and they all saw the benefit of Linux and kind of maintaining that integrity. So they said, okay, based on Linux, we won't sue each other, but we'll sue each other on everything else. But we think that this is actually a good thing, and there's a lot of benefit that can come from this. So let's agree not to sue. And so they've all, they have their contractual arrangements, but then they invested in creating OIN. And so now I think we have 600 licensees. And there are different companies, individual developers, startups, just everything that have all taken this, this pledge to this non-aggression pledge is what we call it. We have a patent pool, but everyone has access, that's a licensee, to this pool freely. But yeah, it was founded based on, IBM is a behemoth in patents, but they did see the benefit in maybe not suing for everything. Anyone else? Yeah.
You mentioned earlier that they don't search like scientific literature when they're searching for patents. Would it be useful then to take your prior publications from the research you did and turn them into defensive publications?
Yeah.
That would be okay.
Yeah, and we would work with you to do that so that it doesn't, I mean, it can be a thesis that you use as a defensive publication, or you can decide to make it shorter, so maybe a longer abstract. It's up to you on what you want to do, and you can always refer to that publication in your defensive publication. But yeah, I mean, we would definitely work with you for that. Yep.
Is there ever an overage of, I forget what you call the stuff you're submitting to
The prior art?
versus people willing to submit it? Have you ever thought about having a list of volunteers who would voluntarily, you send them something and they submit it?
Yeah, we haven't had that issue yet. And not because prior art is not the easiest thing to find, especially for something that you have to look for the date. You have to look, just there's a bunch of things that come into play. But there are people, I mean, students that we work with, and they get some practice. Like we'll work with law schools, and they can make the submissions and get, the patent law students, and they can kind of get working with the patent office and those kinds of submissions, so that when they graduate, they're already used to using this third-party system that a lot of patent attorneys are not using. I mean, patent attorneys are generally not the most, they can be boring. They can be used to, they're very traditional and conservative. So when a new system comes, they're a little more hesitant to use it. Anyone else? Nope. All right. Well, thank you so much for listening to me.